Thank you for joining us tonight. I'm going to do a couple of brief announcements before we get started. First and foremost, vote June 2nd, deadline. Please get your ballots in. Extremely important. June 13th, we are going to be participating in the Livermore Rodeo. We're asking people to join us. We're hoping to have 50 plus people part of the rodeo wearing red, white, and blue or your indivisible t-shirts. This is a parade, not a protest, and it's in honor of Flag Day. So if you could register, you can go to Livermore Indivisible and you could see all of our actions in that area. And as people are coming in, I'll do one more announcement. June 14th is our monthly meeting in person, and we will have legendary victims attorney Lisa Bloom, who represents Epstein victims, and Dr. Powell with Rights for Girls, a nonprofit advocates for victims of sexual exploitation. We will also have a local representative from Tri-Valley Haven. Okay. And now, welcome to our special session with Livermore Indivisible. Tonight, as tensions and issues continue in the Middle East, we are pleased to host a conversation with Professor Tom Dannenbaum. He is a Frank Stanton Professor of Nuclear Security and Professor of Law at Stanford Law School. He specializes in international law, and his work has been cited on many outlets such as the New York Times, the Washington Post, NPR, BBC, ABC, NBC, just to name a few. Tonight's discussion will focus on U.S. and Israel actions in Iran and Lebanon, and we may also touch on Gaza. We will examine these issues through the lens of international law. Professor Denham, I will let you continue. Also, everyone, questions at the very end, you can put it in the chat. Thank you, sir.
Thank you. Thanks very much for having me, and thanks to all of you for taking time out of your days to think about how international law bears on these various situations in the Middle East. As Shari mentioned, I'm an international lawyer, so I'm going to focus on international law. There are, of course, also domestic legal issues that are implicated, for example, relating to constitutional war powers. And even within international law, there are multiple different domains of international law that are implicated when we think about the conflicts in Lebanon and Iran and the situation in Gaza. But what I'll do is focus on three specific areas of international law that bear on different components of what we're seeing and its implications for the United States in particular. As Shari mentioned, I'll focus specifically on United States and Israeli violations, not because Iran is not also violating international law, it is, and not because other actors such as Hezbollah and Hamas in the Lebanon and Gaza contexts haven't violated international law. They have. But we are in the United States, and what the United States is doing, it is doing in our name. And so its violations are particularly salient and important for us, and particularly significant when we think about what kind of political action is warranted in response. And Israel's violations are particularly important for us because they have been backed to the hilt by the United States and are partners with the United States in the current operations in Iran. When I think about international law in this context, I'm going to, as I said, mention three areas of international law that are relevant. The first is termed the law governing the use of force, also known as the law governing the resort to force. The second is international humanitarian law, also known as the law of armed conflict. And the third is international criminal law. So let me just say a little bit about what each of those things is and how they work before then going into some specifics on their application in the context of Iran, Lebanon, and Gaza. So if we focus on the law governing the resort to force first, this is the legal regime that's codified in the United Nations Charter and has been in place since 1945. And what it does is determine whether and on what basis we engage in war at all. So this is the body of law that tells us when we are going to war and why we perpetuate a particular war. And it's a fairly basic framework. The UN Charter provides that states are prohibited from engaging in a resort to force in their international relations, in other words, against another state or on another state's territory, with two specific exceptions. The first is UN Security Council authorization, and the second is self-defense. Now, of course, there are debates around exactly how broadly to interpret the concept of self-defense and exactly what its boundaries are, and I'll return to those in a moment. But those are the only two grounds on which a state can resort to force, engage in war against another state in international law. The second area of international law is held completely separate and independent from the first. This is the law of armed conflict, also known as international humanitarian law, and it answers a different set of questions. So rather than determining whether or on what basis we're in a war, it determines how we conduct the war. So rather than answering the question of whether, it answers the question of how. How do we conduct the war? How do we protect those who are affected by the war, individuals, communities, and infrastructure? And this body of law is rooted in the Geneva Conventions, the additional protocols to the Geneva Conventions, the Hague Regulations, a series of treaties and customs on specific issues like cultural heritage, the environment, protection of children, and others. And there are many, many different rules in this body of law. So it's a much more complicated and detailed framework of law than the law governing the resort to force, which is structured in that fairly basic way that I described earlier. But some of the key components of international humanitarian law, just so that we have an idea of what it requires, are the rule of distinction, that you can't target civilians or civilian populations or civilian objects. The rule prohibiting indiscriminate attacks, that it's not just that you can't target those things, but you have to discreetly target specific military objectives or groups of combatants rather than areas in which there are both military objectives and civilian objects, and you target the whole area. You can't do that. You have to instead discreetly target specific targets within the armed conflict. The third key rule here is the rule of precautions, the duty to do everything feasible to verify the legality of each target status and to do everything feasible to minimize any civilian harm that would arise from targeting specific military objectives. And then finally, in the basic rules on the conduct of hostilities, there's a principle of proportionality. In other words, the rule that you can't engage in an attack at all, even if it is against a specific military objective, if the civilian harm expected from that attack would be excessive in relation to the concrete and direct military advantage anticipated from neutralizing that military objective. This is supplemented by specific heightened protections for cultural heritage, hospitals, objects indispensable to survival, such as food, water, and food and water systems, as well as specific rules protecting populations from endangerment, protecting against the exploitation of rules, such as individuals presenting as civilians in order to get proximate to an adversary in order to take them out, as well as rules relating to the control of populations, detainees, treatment of detainees and persons under one's control, and rules that are specific to contexts of belligerent occupation, where one state controls the territory of another state or controls the territory of a self-determining unit without that state or self-determining unit's consent. So there's a whole panoply of rules that are applicable there. But the key point is that because these rules are independent from the first body of law, the law governing the resort to force, they apply equally to all parties to the conflict, regardless of which one is the aggressor and regardless of which one is acting in self-defense. And that can provide some clarity around violations of the conduct of war, even when there is dispute regarding the law governing the resort to force. The third legal framework, just very briefly before we start to get into the details on Iran, Lebanon, and Gaza, is international criminal law. The key distinguishing feature of this body of law as compared to the first two that I mentioned is those two are both addressed primarily to states. In other words, the violator, when those rules are violated, is the state itself, the United States, Israel, Iran, etc. International criminal law, on the other hand, applies individual responsibility to specific human beings who can then be held criminally responsible, prosecuted, and ultimately, if convicted, incarcerated for violations of international law. And that body of law, international criminal law, is in part derivative of the first two bodies of law. That's to say that serious violations of one of the first two bodies of law can qualify as an international crime that therefore implicates the individual criminal responsibility of the specific human beings who were responsible for that violation. So a serious violation of the law governing the resort to force entails the crime of aggression. Serious violations of international humanitarian law entail war crimes. And then we have two additional criminal categories in international criminal law: crimes against humanity and genocide, which can occur outside of armed conflict, unlike war crimes and aggression, but entail certain scale and atrocity features that distinguish them from war crimes, which can occur on a fairly small scale basis. So crimes against humanity are widespread or systematic attacks against the civilian population, and genocide is a particular kind of attack on a protected group with the intent to destroy that group in whole or in part. And what it means to say something is an international crime is that not only that the individual person can be held responsible for it, or the set of individuals who were responsible for the crime can be held responsible for it, but that they can be held responsible in an international court if that court has jurisdiction, such as the International Criminal Court, which, for example, has jurisdiction over all war crimes, crimes against humanity, or genocide committed in Gaza, and can be held responsible in foreign domestic courts that lack any ordinary jurisdictional nexus. So prominently, for example, there have been multiple prosecutions of Syrian nationals for crimes in Syria against Syrian nationals in courts in Germany. Germany doesn't have an ordinary jurisdictional nexus to those crimes in Syria, but because the crimes in question are war crimes or crimes against humanity, they implicate universal jurisdiction, which means a state anywhere in the world can engage in criminal prosecution of those acts, regardless of where the acts themselves took place and regardless of the nationalities of the perpetrators and victims. So those are the three key areas of law that underpin how we'll be thinking about Iran, Lebanon, and Palestine, and specifically in this instance, Gaza. So when we're thinking about the law governing the resort to force, the clearest cut case is the Iranian case. Israel and the United States engaged in an attack on Iran on the 28th of February and have perpetuated a war against Iran subsequent to that, obviously with a ceasefire in the middle of that, but that ceasefire has not yet reached the point of a full peaceful conclusion. That attack was not pursuant to a Security Council authorization. No Security Council authorization was even sought. So the only open question is whether Israel and the United States acted defensively. And it's very clear, and the overwhelming majority of international lawyers are in consensus on this, and I include myself in that consensus, that they did not act with a defensive basis. Iran had not engaged in an armed attack on Israel, the United States, or any other state that was seeking their defensive assistance. It was not poised imminently to engage in such an attack, and no credible evidence has been brought forward to suggest that it was. That alone essentially ends the legal analysis on the dominant view of international law. There is a minority view that is articulated by a small number of states that allows for a more expansive interpretation of self-defense, and specifically allows for self-defense when the last window of opportunity is closing, within which one would have the opportunity to quell an aggressive threat by a state that would then engage in that aggression further down the line. That is usually invoked with respect to the development of nuclear
May I check that
weapons.
for you?
And the claim is essentially that if the state in question were to develop nuclear weapons, it would then have a capability that would preclude effective defensive force subsequently. And so if you're certain that it's A, going to develop the weapons, and B, then later down the line going to engage in aggression, the claim is that you can engage in defensive force to stop that from happening. That's an extremely controversial interpretation of the law. It's not one that I share. But even if one thought that it were the correct interpretation of the law, even that threshold hasn't been satisfied here, because there is no credible evidence that Iran was A, certain to engage in aggression against either of the states involved or a third state that might have requested their assistance, or that the last window of opportunity to preclude it engaging in that aggression was closing. Instead, what the United States has essentially argued is that this was an opportune moment to hit Iran because it was weak and degrade its military capabilities, but not that it wouldn't have been possible to act defensively further down the line, or that there was any certainty that an aggression was going to occur down the line. So it's fairly clear that this was an unlawful resort to force. The only two other claims that have been marginally made in this respect are one, that Israel and the United States were already in an armed conflict with Iran, but A, that's on the facts not correct in terms of the legal implications of previous encounters between Iran, the United States, Israel, and Iranian-backed non-state actors. But B, even if they were already in an armed conflict through proxies, that would not itself provide a defensive basis for this full-scale aggression against Iran. That would still need to be evaluated pursuant to the law governing the resort to force, and there's no basis for its use here. The final argument that's sometimes been offered, and Marco Rubio offered this most prominently, was Israel was going to attack, and so the United States had to attack because if Israel had attacked, Iran would have attacked the United States. And so the only way to preclude Iran's effective attack on the United States in response to Israel's attack was for the United States to join the attack. But that, I think, fairly self-evidently doesn't provide a basis for joining the aggression that was going to precipitate Iran's response. It instead provides a basis for using the obvious leverage that the United States has to stop Israel from engaging in the initial aggression that would have prompted the response. So there's really no legal basis at all for resorting to force in this context. It is straightforwardly an aggressive war without international legal underpinning. Now, some have said, okay, it's illegal, but maybe it's still legitimate. Sometimes it can be morally justified to violate the law in order to achieve some fundamental principle of justice. But first of all, that is, of course, itself a highly controversial idea. And secondly, the very narrow conditions under which we would ever recognize lawbreaking as morally legitimate require, among other things, articulating a principled justification for the resort to force, notwithstanding its illegality, seeking multilateral buy-in on that principled basis for the resort to force, and accepting that that principle could be applied in reverse, and then tailoring the resort to force very narrowly pursuant to that moral imperative. And none of those conditions has been satisfied in this context. Israel and the United States have not articulated any principled basis for the resort to force. They have not sought multilateral buy-in. They did not engage the General Assembly or the Security Council or any other international organization to try and support the initial resort to force. They do not have a principle to which they could point that they would accept in reverse. Iran is engaged in crimes against humanity against its own people, including earlier this year. But this intervention is not being tailored to prevent human rights atrocities by Iran against its own people. In fact, it's involved the threat of human rights atrocities against those very people. Moreover, Israel has engaged in crimes against humanity in Gaza, and the United States is engaged in crimes against humanity right now in the Caribbean and the Pacific through its killing spree against boats and persons potentially carrying drugs in those boats throughout those areas. And so they clearly would not accept the fact of engaging in crimes against humanity as a basis for another state to use force against them. They can't point to Iran's saber rattling or even its extreme threats, such as threats historically to wipe Israel off the map, because the United States leader, Donald Trump, threatened to end Iranian civilization. And Israel and Israeli politicians have repeatedly threatened to preclude the viability of a Palestinian state and to eliminate the possibility of Palestinian identity while engaging in massive violations in Gaza and the West Bank. So there is no principled basis to which the United States or Israel could point in order to support what would be an illegal violation of international law for some alternative moral imperative. And that's before we even get into the way that the war has been conducted. This is a war that was pursued on the basis of powerful states seeking to assert their power to achieve their interests without any regard for law at all. So then let's turn to the question of the conduct of war, the law of armed conflict, international humanitarian law. When we're evaluating the law of armed conflict, especially when we're evaluating it in real time from the outside without necessarily seeing all of the details of how military operations are taking place, there is significant complexity in trying to determine whether violations have occurred. A particular impact may have been because the attacking force missed its target. In any event, any specific object can become a military objective if it's being used to contribute to military action, and we don't necessarily know how each object is being used at any given moment. We don't know what information the attacking force had and the degree to which it might therefore have made an honest mistake that led to a tragic outcome. And when we're thinking about proportionality, we would need to know the military advantage anticipated from the attack in order to determine whether collateral harm inflicted on civilians or civilian objects was excessive. So there are multiple different epistemic challenges to make a determination as to whether the law has been violated. But notwithstanding those challenges, we can see multiple components, both of the context leading into this war and the way that the war is being conducted, that give rise to very serious concerns about international humanitarian law violation by the United States and Israel, including potentially war crimes. The context going in is important. That context includes the Secretary of Defense firing the top JAGs from each of the military services. That's the top legal advisor from each of the military services upon entering into office. Dismantling the Civilian Protection Center at the Pentagon, which is the primary center that was designed to, across the services, facilitate the minimization of civilian harm in military operations and ensure the elimination of mistakes in that respect. The Secretary of Defense has repeatedly disparaged and degraded JAG and legal advice in general in military operations. He's decried what he calls tepid legality and pearl clutching in favor instead of what he calls maximum lethality. Donald Trump has said he doesn't need international law when asked about that particular framework. And the Secretary of Defense on the 13th of March did something more significant in terms of rhetoric, which is he said in a press conference that there would be no quarter. Issuing a declaration of denial of quarter is itself in violation of international humanitarian law simply through the declaration. And it can qualify as a war crime where there is the requisite intent. So all of these components, just about rhetoric, should shift how we think about the presumptions that we're applying to what we then see in terms of operations. And that's before we even get into the most chilling rhetoric that the president issued as we built up to the ceasefire on the 7th of April, for example, saying that he would end Iranian civilization after days of threatening to bomb Iran to the Stone Ages and destroy every bridge and component of power infrastructure in Iran, which would unambiguously not only have been war crimes, but crimes against humanity had he indeed perpetrated those acts and consummated those threats. So that's all in terms of then how we think about the operations that we do see. We have to think about them against that backdrop of how international law is being degraded throughout the military institution from the top. When we think about specific military operations, I'll just talk about three. There are many that we could discuss in the context of Iran and Lebanon, but I'll talk about two in Iran, one in Lebanon, and then I'll turn briefly to Gaza. So if you think about Iran, the most striking and at this point infamous of the various different US actions was the strike on the very first day of the conflict, the 28th of February, on the elementary school in Minab. This ultimately killed at least 150 civilians. Some reports have suggested over 170, the overwhelming majority of them young children. It is clear that this was a functioning school. It was not on a military base, and it was not hosting military equipment. There's no information suggesting that either of those things is the case. So this was a civilian object that was in that moment housing a significant number of civilians, the overwhelming majority of them children. There's no indication at all that anybody in this school was participating in hostilities. So it was a protected object, and the people within it were protected people, protected persons under international humanitarian law. It does not appear that the United States was trying to hit something else and hit this erroneously. Instead, the primary justification appears to be, although we still don't have the full investigative reports, and so this is mostly on the basis of investigative reporting, and it should be noted that there is some equivocation and inconsistency in the way the administration has described what happened. But the most likely justification that that investigative report will ultimately provide is that they didn't know that it was a school and instead thought that it was a military objective based on its proximity to IRGC buildings or compounds, and that they thought it was either part of that set of IRGC compounds or buildings, or they were operating on the basis of historical data, 10-year-old data, pursuant to which it was part of one of those buildings or compounds. But that itself would not be exonerating under international humanitarian law. Because if you'll recall, one of the rules of international humanitarian law is to do everything feasible to verify the status of the target. And in this case, there are multiple reasons to believe that not everything feasible was done to verify the status of the target. The first is that this was a deliberate targeting attack. It wasn't dynamic in the context of ongoing hostilities. This was on day one when the US and Israel were engaged in a unilateral attack, not engaged in crossfire with Iranian forces. It was an attack based on a target list that was developed before the conflict even began, when the feasibility of verification is at its apex, when there was time, space, and opportunity to engage in a full verification process of each of the targets that would be targeted on that first day. And within a day, open source investigators had determined, based on open source satellite information, that this was a functioning school and that it could clearly be identified as such from open source information. Moreover, as we know, the Civilian Protection Center had been more or less dismantled, so the mechanisms that the Department of Defense would ordinarily have used to ensure full verification and elimination of mistakes had themselves been diminished deliberately as a matter of policy by this administration. So when we take all of those components together, it is clear that feasible verification mechanisms were not taken and that therefore this violated international humanitarian law. If the commanders in question took a substantial and unjustifiable risk and accepted a substantial and unjustifiable risk of this being a civilian object, including civilian persons, then that would also qualify as a war crime on the basis of recklessly targeting a civilian object or civilian persons. But at a very bare minimum, it is a violation of international humanitarian law due to the failure to exercise feasible precautions. The second case that's worth focusing on is the Israeli strikes on oil depots around Tehran on the 7th of March. So this is an instance where Israel struck 4 oil depots around Tehran. There's, again, no ambiguity that this was a mistake. They didn't erroneously target these things. All 4 were hit simultaneously, and they came out and said, we targeted these depots. Were the depots military objectives? Israel gave 2 explanations for why it targeted them. One was that they provided economic resources to the Iranian regime. The other is that they provided fuel to military vehicles. The first doesn't render the depots military objectives. That would not be a lawful basis for targeting any of them. The second can render them military objectives. However, that would need to be determined for each of the specific depots, that each of them was contributing fuel to military vehicles. But more fundamentally, even if we accept that as being the case, the rule of proportionality would still have to be complied with. Bear in mind that Iran is an oil-rich nation. So the military advantage associated with taking out these 4 depots is attriting the oil supply to military vehicles in a context in which that oil supply is unlikely to run out. That was done in a context in which those oil depots were distributed across the area of Tehran, which is a city of over 9 million civilians. The consequence was black smoke across Tehran, acidic rain, and what health experts predict will be decades of chronic health conditions arising from the soot and the respiratory challenges, as well as the pollution effects that will arise from those attacks. It is very difficult to conceive of how the military advantage associated with attriting those oil supplies could possibly justify that level of civilian harm. Proportionality is always a judgment call, and people disagree on exactly where the threshold is. But one way to gut check whether or not it's been breached is to ask the question whether the commander would have authorized the attack if the civilians affected were their own civilians, in this case, Israeli civilians. And I think for that military advantage, given those kinds of health complications across a civilian population of that size, the question answers itself. The final example is to turn to Lebanon. Again, we could look at multiple different situations in each of these conflicts. But turning to Lebanon, perhaps the most striking has been the forced displacement of Lebanese population from the southern Lebanon area. It's estimated that over 1 million people have been displaced from their homes, an area of about 15% of Lebanon, 2,000 square kilometers, and that this has been done in conjunction with mass controlled demolitions of multiple villages in the southern Lebanon area. International humanitarian law does allow forced evacuation in very specific contexts around absolute military imperative or civilian security. But it also places conditions on those kinds of evacuations. And those conditions include humanitarian requirements associated with the evacuations, but more importantly, the temporariness of the evacuations. And the combination of both statements by Israel Katz, the Israeli defense minister, and the mass demolition of homes makes it clear that this is not temporary for civilian protection or immediate absolute military imperative, but is instead a systematic displacement of the population from the southern area. That's exacerbated by the fact that reports indicate, and again, statements by Israel Katz seem to confirm, that this is focused specifically on the displacement of Shiite civilians from southern Lebanon, not, for example, Christian or Druze civilians from southern Lebanon. An ethnic discriminatory component or religious discriminatory component that itself precludes classifying this as either based on civilian security, which wouldn't be determined associated with religious denomination, or military imperative, which would have to be about, again, moving civilians in general from an area so as to facilitate a particular military operation rather than a specific subcategory of civilians on the basis of their religious or ethnic identity. So again, we can see a significant violation of international humanitarian law in that context that again could rise fairly straightforwardly to the level of a war crime and potentially a crime against humanity. That's also a pattern that follows from what we saw multiple times in Gaza, where the overwhelming majority of the population was displaced over and over and over again, with a combination of displacement and mass demolition and destruction of homes, so that when they ultimately returned to the areas from which they'd been displaced, they did not have homes to return to. But I'll focus on another aspect of Gaza. Over the course of what's happened in Gaza, and indeed what's happened in Palestine more generally over the last decades, there are so many violations that we could focus on. But what I'll focus on specifically in Gaza over the last 2.5 years is the war crime of starvation of civilians as a method of warfare. This is not only the crux of the arrest warrants for Israeli Prime Minister Benjamin Netanyahu from the International Criminal Court and former Defense Minister Yoav Gallant from the International Criminal Court, but also the crux of South Africa's case at the International Court of Justice against Israel under the Genocide Convention, although I'm going to focus on the international humanitarian law underpinning, and the genocide analysis requires an additional set of components. Starvation of civilians as a method of warfare is a complicated legal framework, and the best way to understand it is to understand 3 predicate points. The first is the basic rule of international humanitarian law, which I mentioned earlier, which is to distinguish in all military operations between civilians, the civilian population, civilian objects on the one hand, and military objectives and combatants on the other. and to direct military operations exclusively at the latter. The distinction between civilians and the civilian population there is important because the second predicate point is how to understand what a civilian population is. And the crucial component here is that international humanitarian law is explicit on this point. A civilian population doesn't lose its civilian character in virtue of the presence of combatants within that population. So if the population at the aggregate level is predominantly civilian, then you cannot deploy military operations, not just kinetic attacks, military operations of any kind against that population, even if the ultimate goal is to neutralize the combatants within that population. You have to discreetly deploy those military operations against those specific combatants and military objectives. You can't deploy against the population as a whole. That matters because the population of Gaza as a whole was unambiguously, and this is not anywhere close to a legally marginal call, a civilian population as a whole, notwithstanding the presence of combatants within that population. By US intelligence estimates, if you look at the number of fighting forces that they anticipate from Hamas, Palestinian Islamic Jihad, and other armed groups in Gaza, the population was 98% civilian. Half of the population were children. So it's a civilian population, and that applies also to specific subzones and regions of Gaza. The third predicate point is that starvation is both a process and an outcome. So starvation as an outcome is a state of fatal or near fatal malnutrition. But starvation is also a transitive process. If you take a well-nourished detainee, lock them up, and deny them a supply of food, at that moment you've begun a process of starvation, even though they're not yet in an end state of starvation. So all of these components are then important to understanding how the prohibition applies, which is to say that it prohibits engaging in the deprivation of objects indispensable to survival, either, and objects indispensable to survival here is just a legal term of art for food and water systems, medicines, and other essentials. It's prohibited to engage in deprivation of those things, either for the purpose of denying their sustenance value to a civilian population, and that can occur even if the population is not yet in a state of starvation, and it can occur even if the purpose is to squeeze the combatants within that population. Or for any other military purpose, in other words, purposes other than denying the sustenance value of those things, if it's known that civilians will starve as a result. If we look at Gaza, we can see multiple modalities of the deprivation of objects indispensable to survival. That includes moments of total siege, where absolutely no humanitarian access was granted in the first 2 weeks after October 7th, and then most potently in the 79-day period between March 2nd and May 18th of 2025, as well as for prolonged periods in specific areas of northern Gaza. We can see it also in the other periods where significant impediments were placed on humanitarian access, such that it was being delivered at far below the needed rate, even though those were not periods of total siege and total denial of humanitarian access. And you can see it through the destruction of the food system, the water system, the agricultural system, the residential system, and the medical system in Gaza through a combination of kinetic attacks, demolition, bulldozing, and razing. That complex of deprivation of objects indispensable to survival was deployed at certain points explicitly for the purpose of denying the sustenance value of those things. That was clear from the statements of Yoav Gallant and Ghassan Alian at the beginning of the October 2023 siege and Israel Katz in the 2025 siege. But even if one thought there were an ambiguity about whether or not this was done to deny sustenance value, it was clear that it was done at multiple points, knowing that civilians would starve as a result. That's clearest at the end of 2023 into early 2024, before the uptick in humanitarian access into March and April of 2024, and then even more severely in spring of 2025 going into summer 2025, at which point the Integrated Food Security Phase Classification Famine Review Committee determined that Gaza governorate had descended into famine. So it's clear that starvation of civilians as a method of warfare was perpetrated here. That is the crux, as I said, of the war crimes and crimes against humanity arrest warrants against Netanyahu and Gallant. And it's also a key component of the argument that will now be presented to the International Court of Justice on genocide, which is in a state responsibility case rather than an individual responsibility case. But let me just conclude by saying, so we see these violations. We don't just see violations, but we see brazen violations by some of the most powerful actors in the system. And by brazen violation, I just mean violations without even a fig leaf of legal justification. And we see this at the same time as direct attacks on the international institutions that are designed to identify and uphold international law and facilitate accountability in the face of its violations, most brazenly through the Trump administration's crippling economic sanctions on 3 prosecutors at the International Criminal Court, 6 judges at the International Criminal Court, a UN Special Rapporteur, and multiple civil society organizations, all simply for seeking to apply the law to Israeli actions in Gaza, using a sanctions system that was designed for countering terrorism, but is now being redeployed to counter legal advocacy. So in the face of all of this, you might think, what's ultimately even the point of continuing to talk about international law when it's being brazenly violated and the system is breaking before our eyes? But there are several reasons why I'm very resistant to reaching that conclusion. The first is that that's precisely what people like Netanyahu, Pete Hegseth, Donald Trump, Vladimir Putin want. They are devoting resources to dismantling these legal constraints because the legal constraints matter and they see them as obstacles to achieving what they're doing. So conceding that and simply saying international law doesn't matter anymore, this is a domain of power, is conceding precisely what they are seeking. The second reason is that it would be a failure of solidarity with the human rights defenders, advocates, and survivors of these crimes who are seeking to invoke international law as we speak and seeking to do so through various institutional mechanisms that are still functioning and still deserve our support. But the third is that it would be a failure of political imagination because international law has, throughout its history, been regenerated and rebuilt and built in more progressive ways in the emergence from catastrophe. Whether it's the Geneva Conventions, the United Nations Charter, whether it's the International Criminal Court, any development in international law has come out of catastrophe. And we have key rules here that are being violated. Those violations have no statute of limitations. And so the most likely route to holding perpetrators accountable is to insist on those rules and simultaneously to seek to reimagine and rebuild a system that's more robust and resilient. And just to give you one specific example of this, in 2016, when he was asked about International Criminal Court investigations into the so-called war on drugs in the Philippines, Rodrigo Duterte said bluntly to the press member who was asking him this question, the ICC is bullshit. I'm not afraid of the ICC. 2 years later, as president of the Philippines in 2018, he said they'll never have jurisdiction over me in a million years, and his administration withdrew the Philippines from the International Criminal Court. But last year, the Philippines arrested Rodrigo Duterte and transferred him to The Hague, to the custody of the International Criminal Court, where charges against him were just recently confirmed and where he will now face trial beginning in November of this year for crimes against humanity perpetrated in the Philippines at a time when Filipino human rights defenders were engaging courageously at significant risk to themselves in gathering the evidence that would ultimately provide the basis for the accountability that is now being applied in his case, and doing so in a moment when everybody was telling them that this was politically unrealistic and that they were endangering themselves in a futile effort. So these are mechanisms that will still be there when the political moment is more propitious. And to give up on them right now because of the catastrophes that we're seeing would be to cede one of the most valuable normative tools that we have available to us for mobilizing politically across lines of division, across national lines of division, and globally to seek accountability regarding those who have engaged in the violations, only some of which I've mentioned in the course of what I was describing earlier. So I think I went actually quite significantly over how long I said I would, but I'll stop there and allow questions.
All right, very good.